the Commission is going to sit and do that. Right now, it is not yet done, and therefore cannot impede our processes of work like this one, which is very urgent. But I know as leadership of committees, we are committed to transparency in our operation, which the chairman has reiterated. Thank you.
Thank you very much, Chair. Budget. Yes, please.
Thank you, Chair. Chair, yesterday in the former chairman's report, he hinted on the issue of you engaging the leadership of Parliament to consider funding more the Finance Committee. I don't know whether that has been done, because if they release the budget allocation, it may be difficult. I don't know whether you have already engaged the leadership so that we are not caught out of time.
Thank you for the follow-up. I have not yet, and I decided that today, since we have designated the deputy, we will make a follow-up through our commissioner, who is a member of the committee. That's Honorable Faith Nakut, to ensure that the allocations should not be on pro rata basis, but should be based on the costed work plans. And accordingly, we should actually be able to get what is due to us to enable us to achieve our objectives. So he will do it today.
Chair, maybe additional to what you said, not only costed work plans, but also the mandate that the committee has, which is very wide. So that can be reflected in the number of entities that are supervised by this committee, the subventions that are supervised by this committee, which gives you a big workload. And therefore, some of the retreats you'll have, for example, during the tax bills, would require more money than any other committee. So I would like you to spread it further when you're justifying the need for more money. Thank you.
Yeah, thank you very much for that guidance. We shall take it up, and at an appropriate time, the costed work plan will be shared amongst us, as well as the release for the first quarter. I thank you. Next item.
Consideration of the income tax and excise duty amendment bills 2026.
Honorable colleagues, you recall yesterday in the House, the presiding officer referred the two bills, one on income tax amendment bill 2026, and then the excise duty amendment act 2026 for us for reconsideration. He read the letter. Some of us were not present, and so I now call upon the clerk to read the letter to us, so that from there we have the lead counsel who will guide us through the process. I thank you. Over to you.
The letter is dated 10th July 2026. It's addressed to the Right Honorable Jacob Maxon Zobot, Speaker, Parliament of Uganda, Kampala. The title is The Income Tax Amendment Bill 2026 and the Excise Duty Amendment Bill 2026. I posted this letter on the group WhatsApp. In accordance with Article 91 3B and C of the Constitution of the Republic of Uganda, I hereby recommit Clause 11 of the Income Tax Amendment Bill 2026 and Clause 2E of the Excise Duty Amendment Bill 2026 to Parliament for reconsideration. This is on account of the following observations and concerns. A. Income Tax Amendment Bill 2026. Parliament passed Clause 11 of the Income Tax Amendment Bill 2026, which amends Section 131 of the Income Tax Act to impose withholding tax on winnings from betting and gaming calculated as the difference between the payout and the stake. However, in passing of the bill, an additional provision was introduced exempting winnings derived from land-based casinos licensed under the Lotteries and Gaming Act from withholding tax. The exemption creates opportunities for tax avoidance and revenue leakage. By removing an entire category of gaming winnings from withholding tax, the amendment creates incentives for transactions to be structured through land-based casinos in order to obtain a tax advantage not available to other gaming operators. In addition, the amendment creates an unjustified distinction between land-based casinos and operators conducting substantially similar gaming activities through online platforms. Both derive income from the same economic activity, and there is no justification for exempting one category while taxing the other. B. The Excise Duty Amendment Bill 2026. Parliament also passed Clause 2E of the Excise Duty Amendment Bill 2026, which increases excise duty on single-use plastics from 2.5% or $70 per ton, whichever is higher, to 25% or $1,500 per ton, whichever is higher. The proposed increase is substantial and is likely to impose significant cost pressures on manufacturers engaged in the production and use of single-use plastics. It may adversely affect production, investment, and employment within the sector. In addition, viable alternatives to plastic packaging are not yet readily available in Uganda. I therefore consider that the matter requires further study before the proposed increase is implemented as a policy measure for advancing environmental conservation objectives. Recommittal. Given the above observations and concerns, I am constrained to assent to the Income Tax Amendment Bill 2026 and the Excise Duty Amendment Bill 2026. Accordingly, I hereby recommit the following provisions to Parliament for reconsideration as follows. 1. Clause 11 of the Income Tax Amendment Bill 2026 be amended to read: the Principal Act is amended by substituting for Section 131 as follows. 131. Withholding of tax on payments for winnings of betting or gaming. 1. A person who makes payment for winnings of betting or gaming shall withhold tax on the winnings at the rate prescribed in Part 11 of Schedule 4 to this Act. 2. For purposes of subsection 1, winnings means the difference between the payout and the staked amount. 3. This section does not apply to winnings paid by a person licensed to conduct a national lottery under Section 23 of the Lotteries and Gaming Act. 2. Clause 2E of the Excise Duty Amendment Bill 2026 be amended to read: 11. Plastics. If there is a table there. A. Plastic granules used in the manufacture of single-use plastic products. Single-use plastic products including disposable plastic cups, lids, plates, cutlery, bags, sachets, bottles, straws and stirrers, cling films and wraps, jars and lids, sacks and bags of polymers of ethylene except vacuum packaging bags for food, juices, tea and coffee. Sacks and bags for direct use in the manufacture of sanitary pads. Multiple-use plastics and plastic granules used in the manufacture of multiple-use plastics. and plastic granules used in the manufacture of plastic products used for packaging pharmaceutical products and plastic products used for packaging pharmaceutical products. In the column on the right has 2.5% or $70 per ton, whichever is higher. Signed by Yoweri Kaguta Museveni, President of the Republic of Uganda. The letter is copied to the Right Honorable Prime Minister, the Attorney General, the Minister of Finance, all Ministers of State for Finance, the Permanent Secretary, Secretary to the Treasurer, the Principal Private Secretary to His Excellency the President.
Thank you very much. Honorable members, you have heard. I suggest that we listen to the presentation from our technical team to give us a technical insight into this letter before we open for the discussion. And we shall be facilitated by our Deputy Chair. Thank you.
Okay, thank you very much, Chair, for giving me this opportunity to facilitate the presentation by the technical team. So we are not going to waste time. Is the technical team ready? Can you flash your PowerPoint presentation?
Thank you, Chair.
So you can proceed.
Thank you, Chair. Good morning, honorable members. My name is John Tamale Mirundi. I'm Principal Legislative Counsel here at Parliament. I'm sitting in for my colleague, Tabitha, who is out of the country. I serve on the Committee of Legal and Parliamentary Affairs. I've been here for about 10 years in Parliament. Honorable Chair, we tried to panel beat our presentation. It's not yet ready, but most of the things I have in my brain, I can expound some of these matters here. At a later point, I'll be able to share with my colleagues, if you can allow me, sir.
So you don't have the presentation
No, sir.
yet?
Not yet.
So you want to make a presentation off cuff?
Yes.
Okay, since it is the only thing you have, I don't think we have much choice. But do you have intentions of sending us that presentation
Definitely,
later?
Definitely, Chair.
How long is it going to take?
My presentation, not more than
The
10 minutes.
PowerPoint presentation.
The one I'll share, I can share with my colleagues after this meeting, in an hour, after the meeting.
In an hour's time. I don't know what members have to say. He does not have a presentation. It will be ready in 1 hour's time, but he wants to present off cuff. Yes, Honorable Amos Kankunda.
Honorable Chair, I think what he's presenting is merely his legal comments on the opinion of the President in order to guide us as a committee. Just to put it in writing, what he's saying, I think, is to write it for drafting later, but right now, a particular presentation at PowerPoint is not necessary as long as he makes comments on the observations. That is my opinion.
Okay, I think we can proceed. You can go ahead, Mr. Tamale Mirundi.
Thank you, Chair, and sorry for this. Honorable members, you are aware, my colleague is going to show the bills and the presentation copy that was sent to the President and the necessary answers. Honorable members, you recall Parliament considered these bills and passed them. Now, the processes that we are at this point, are processes that arise when the President does not assent to a bill. Under the Constitution, under Article 91, the President is given 3 options when a bill is presented for his assent. And I want to read for you, honorable members, what the President is required to do. Under Article 91, honorable members, the law requires, the Constitution requires that subject to the provisions of the Constitution, the power of Parliament to make laws shall be exercised through bills passed by Parliament and assented to by the President. A bill passed by Parliament shall, as soon as possible,
What time?
be presented to the President for assent. Now, the President is given 3 options. The President has 30 days within which, after a bill has been presented to him, to either assent to the bill, B, return the bill to Parliament with the request that the bill or a particular provision of the bill be reconsidered by Parliament, or notify the Speaker that he or she refuses to assent to the bill. So those are the 3 options given to the President. Now, honorable members, the President returned these 2 bills under Article 91(3), Clause B and C. Clause B requires that the President informs you of his reasons for refusing to assent to a bill, and C allows the President to merely inform you that I'll not sign this bill. Okay? Now, the President was good enough in his statement to give us reasons for withholding his assent. And the reasons are articulated in the letter. Our role as a committee in processing this letter is guided by Rule 190. Just a moment, honorable member, let me take you there. Do you have a copy of the rules? Rule 149 of the Rules of Procedure. And it tells you that once a bill is referred to the committee like it is now, your role as a committee is to consider the request of the President and report to the House within 2 weeks. Now, the House only allowed us up to tomorrow, I think up to 2 p.m. So this period has been shortened. But also, your role as a committee is restricted to only dealing with what the President returned. Only. The President returned 2 clauses. One clause in the Income Tax Act, and the other clause is in the excise duty. You cannot open up these 2 bills to other matters not referred to by the President. You are only restricted to those matters which the President returned. However much you want to amend things that are provided elsewhere, you cannot. However, if a matter, under the rules, if a matter is connected or incidental to the one returned by the President, i.e. if in this bill there was a provision on taxation of plastic somewhere else in clause, let's say 20, you can consider that as well, as long as it is incidental to what the President returned. That is our role is restricted. It's not to open up the entire bill again to stakeholders, to views, to change. No. Only restrict yourself to clause 11, the proposed amendment to section 131, and clause 1 of the excise duty, the proposed amendment in part 11. That's all. Honorable members, you recall that I'll take you through the bill and the presentation copy. What we have when a bill is returned to the President is not the original bill that was introduced in the House, because it has gone through amendments. Okay? What we use in processing this bill is the presentation copy that was sent to the President. Once a bill is passed by you members in the House, we prepare what we call a presentation copy on behalf of the Clerk to Parliament. And that presentation copy includes all amendments that have been proposed and accepted by the House on the bill. And we present it to the President for assent. Now, that presentation copy, I think is the one that my colleagues are showing. So, in far as the Income Tax Act is concerned, the President is concerned about Clause 11 of the Income Tax Act. The Clause 11 in the Income Tax Act, in the presentation copy, was Clause 14 of the bill that was introduced. Chair, I hope we are clear. We are using the presentation copy, the copy that the President was sent to. This copy in the presentation copy, the particular provision the President has concern with is Clause 11. Okay? But in the original bill that was presented by government, it is Clause 14. So this proposal in Clause 14 was proposing an amendment to Section 131 of the Income Tax Act on withholding tax on payments for winnings and bit of withholding of tax on payments for winnings of betting and gaming. Under that act, under the bill, honorable members, clause 14 of the bill sought to amend section 131 to expand the provision on withholding tax of payment of winnings of betting and gaming. The proposed amendment prescribed withholding tax on winnings under the fourth schedule, which under Schedule 11, which is at 15%. The bill also proposed a definition of what amounts to winnings. This was not in the Act. It was a new insertion, which was very good because now it has clarified what winnings are subject to tax. One of the elements of a good law is the legality principle. The legality principle is prescribed in Article 12 of the Constitution, 28:12 of the Constitution. And it tells you that some of the things we put in the law must be defined for clarity, so that a person knows what conduct is prohibited or what conduct is allowed, and then they can temper their conduct to fit within. So this proposal of defining what winnings was a very good invention by government. Now, the committee, in its wisdom, so the ministry informed the committee that that a betting or gaming company which pays out winning is required to withhold taxes on these winnings, which are now defined. The winnings were defined as the amount paid out to the player minus the amount they staked. As an example, if I staked 1,000 shillings and I win, let's say, 2 million shillings, the difference between the 1,000 and the 2 million is what is subject to tax, and that is what the provision was proposing. The committee agreed with government, and during the interaction with the committee, Uganda Revenue Authority, and Chair, you can correct me here if I'm wrong, proposed that there should be an additional amendment to the bill to exempt earnings by land-based casinos. Land-based casinos are yes, Chair, sorry.
Thank you so much, and I would even like to remind colleagues in that engagement, rather not necessarily that it was URA that proposed that land-based casinos should be exempt, but from our engagement with the stakeholders said it was very difficult for them to determine when they win. For example, they explained that when you enter a casino, you buy coupons and you go, and the land-based casinos are these tables, the roulettes, the machines that you turn and make money. So when you go to the roulette and make a winning or a loss, or even when you make a winning for demonstration purposes, you move to another machine and move on to another. So their argument was that you cannot determine that at that point when you win on the roulette, you should pay a tax and move to another one. And yet URA was also conceding that they do not have a system that can monitor those winnings. However, when you compare with online is determined and you can see the wins. So that was the argument. And actually, URA itself and Minister of Finance, and I remember it is the minister who moved that we should exempt land-based casinos. But from the argument of the president, he seems to say it doesn't matter. After all, we have defined what winning is. If he goes into the casino and has done all this, when he's cashing out, you will determine the win and you pay withholding tax. And this is the argument. Thank you.
Thank you, Chair. And so now the President is saying, delete that provision that was granting an exemption to land-based casinos from paying withholding tax. Delete it. So that the provision as passed by the committee as introduced in the bill is retained with the small amendments that were made by the committee. And now he proposes that that provision reads as proposed on page 2 of his letter. So at that point, that is what the President seeks from you as members.
Procedure, Chair. Procedure.
Okay, you can go ahead.
Thank you, Honorable Chair. I actually thought that we would iron out the procedural matter first, being that the technical bench was called in to set pace. I think there's a procedural matter, right, Honorable Chair.
What is the procedure matter?
First is about the rules of procedure that bars returning bills that were considered by another parliament, like this one that was considered in the 11th parliament and was passed.
Which rule is that?
Rule 245. Rule 245, sub-rule 1. And if you may, Rule 1, sub-rule 1. It says that a bill, petition, motion, or other business pending before the House or a committee during the term of Parliament lapses upon dissolution of Parliament. If we can extend it to sub-rule 2, notwithstanding sub-rule 1, a bill, petition, motion, or other business pending before the House or a committee may be reinstated in the next Parliament by a resolution of Parliament. Now, it talks about a bill that is pending before the House. As far as the one we are considering is concerned, Parliament had already done its work and disposed of this bill to the President. So in our case, we had already finished our work. So it was not pending before us. It was already with the President when Parliament ended. And we may be violating these rules because it was not pending by the time the 11th Parliament ended. We had already finished with it. So procedurally, I think we may be, I seek your guidance on that.
I think let's get the comments of my senior colleagues, Mr. Bumali, Honorable Kakoza, and then finally, your name once again? Honorable Katabazi.
Mr. Chairman, my colleague is confusing me because when the Legal Counsel read us the Constitution and the rules of procedure, I was saying that when the Legal Counsel read us the Constitution and the rules of procedure, he did give us provisions that allows the President to return the bill. He has categorically stated that this bill is not pending because it was resolved. But the President also has a role to sign. So he's saying this provision and this one, I'm not comfortable signing it. So reconsider it. And by us reconsidering those two provisions, we are not offending any rule. So I expected him to quote us a rule that this committee will be offending by reconsidering the bill. Unfortunately, he has not brought that rule. And I think you could guide him to provide that rule. Then we see whether we are offending any of the rules of procedure.
Honorable Kakoza.
Yeah. I think yesterday in the plenary, the speaker guided very well. I don't know whether my colleague was in the house when he passed a resolution to reinstate any pending business. Despite of that, the command of the Constitution is clear. If the bill has not passed the days when the president within the allowed 45 days, there is no offense, because the command of the Constitution is clear. When the president presents him a copy, he supports to assent or to return it within a particular period, which the speaker guided very well, that he was still in the days. And that's why, maybe colleagues, new colleagues, that's why Parliament, when it's dissolved, the next day you have a sitting, because they don't want to leave a vacuum of government not functioning. So this bill, if it was returned within the allowed days within the Constitution that the president do, then you would have to do nothing. 245, the spirit of 245 is the legacy report of the previous pending business. And once a resolution is passed to reinstate that business, like we asked yesterday, within the 14 sittings of the new parliament, then you can't say that that business reinstated can be connected with a bill brought back with the president. I think there is a difference.
Thank you.
Qualification, Chair.
Let's first listen to him, then you can come up with your clarification.
I think, Honorable Chair, the member posed the question and answered it himself. He referred to the rule. The rule is saying business that is pending in Parliament. But then he resolved it by saying that this is not one of them pending before Parliament. This had already been resolved. So to that very extent, if there is no any other rule that he has to cite before us, I think this matter is properly before us, and I think we need to proceed. Right, Honorable Chair.
Clarification, Chair.
Okay, you can guide with your clarification.
Yes, the rules, Rule 245, Rule 245 talks about a pending bill before Parliament. It's the one that can be reinstated in the next Parliament. This one was not among the pending bills. That was one. Two, I remember the late Right Honorable Jacob Olanya also gave a guidance on such bills basing on Rule 8. And if I can read Rule 8, procedure in case not provided for and precedents. In case of any doubt and for any question of procedure not provided for in these rules, the Speaker shall decide, having regard to the practices of the House, the constitutional provisions and practices or other Commonwealth parliaments, insofar as the practices may be applicable to the Parliament of Uganda. So in this case, Chair, I hope I'm protected. In this case, the late Right Honorable Jacob Olanya provided that, guided that I'll just read here. That in using that rule of procedure, he proposed, he guided that any business dissolved by, considered by a parliament would be bad to be considered by a new parliament. Yeah, that bills that considered by a previous parliament were barred from being reintroduced in the new parliament once the other parliament had been dissolved. So using that guidance, Right Honorable Chair, I think we might be violating our own rules of procedure if we went ahead to consider this. I would rather propose that this could be reintroduced as a new bill amendment that could undergo the normal procedure of introduction and first reading and so on and so forth, but not to be reintroduced as a business from the other parliament when it was already considered. I submit.
Okay, thank you very much. Before I give our outgoing chairman an opportunity, because I can see from my understanding, you are saying this was completed by parliament, and you are referring to a rule that talks about pending parliamentary work. And you are referring to the precedent by the late Jacob Olanya that talks about if something is not provided for under that rule, then the speaker will decide how it is going to be dealt with. And the speaker yesterday guided that we consider this. So this is a bill that was out of parliament. Parliament had done its work, and now it is returning to parliament, meaning it is now the speaker, from what you're reading. It is now the speaker to decide, and the speaker has already decided. So now,
maybe more information.
Because I don't think the rule on pending, because the rule you are reading is on pending parliamentary work. This is completed parliamentary work, and the two are not the same. And the precedent you are talking about, for me, is correct. That since this one was completed and it has come back, then the speaker has the powers to decide. So I want to give an opportunity.
Just a minute, Chair. The rule is that once the speaker has guided, it becomes part of the rules that are going to be followed by the parliament. And therefore, if we also had that guidance from the Right Honorable late Jacob Olanya, we now consider that as part of our rules that we are supposed to follow. Chair, the issue of pending and not pending is clear under Rule 245, and that's what I was referring to, that once the bill is not pending before Parliament, then it cannot come back. It has already been disposed of by Parliament. So we don't need to confuse
some information.
Okay, let me give an opportunity to our outgoing chair.
Yes, thank you so much, Honorable Chair. I think sometimes we need to listen to ourselves, one, and avoid to be seen working against the Parliament as a committee. Yesterday we had a sitting, and these issues were clarified. And I think clarified by the presiding chair and the Attorney General. In my opinion, I hope the colleague was in the Parliament yesterday. If he had any concerns, he should have brought them then so that they were addressed. But we think there is nothing that stops us from proceeding given the guidance of the presiding officer. And secondly, we have been informed of, or rather articles in the Constitution have been evoked talking about the right of the president returning bills for recommittal. Now, that is law. Recommittal means they can be brought for commitment as long as they are within the timelines. And we need to be cognizant of the fact that these, the clauses that we are addressing have an implication on the revenue collection. And that's why it is urgent, so that it does not fail the process of the budget that we have presented. So all this, I don't think, colleagues, that we should go into the back and forth over the law regarding whether they should be committed. Committing this in the committee is the right procedure as guided by Parliament that sat yesterday. So in my opinion, right, Honorable Chair, I think we should proceed and address ourselves to the issues.
I think I'm going to give two people 1 minute each, then we'll have our legal officer, because I don't want us to spend so much time on this. It looks like straightforward. Probably there was anybody who attended yesterday's plenary. This was discussed at length, and we had the technical people, the Attorney General, coming in, and I think we had also some agreements that were made between the Attorney General, the leader of opposition, and they agreed. There was no debate, there was no contestation. So I don't think, apart from trying to inform the member so that he's enlightened on what exactly is going on, let me give Honorable Masaba 1 minute, and then Honorable Kakoza 1 minute, and then just 1 minute you summarize it, then we'll give, your name once again? Hassan. Just, Chirumira, just 1 minute and you summarize, because this has been exhaustively discussed. Eh?
Yes, thank you, Chair. Chair, I also raised my hand here, but I think you didn't see it.
Oh, I didn't see your hand because the computer is with another technical person. Sorry about it. We can also give you 1 minute. Let's just summarize it so that we go into serious business.
Thank you very much, Chair. And you've talked of the meeting of the Attorney General and the Leader of Opposition, and I happen to have been part, yes, as part of that meeting. And we did come to agreement. First and foremost, the bill we are dealing with was no longer with the committee. So it's not part of business that lapsed with the 11th Parliament. It had been sent to the President. So it was not, the report was presented, adopted, and then sent to the President. So it's not, it does not come under Rule 245 because it was no longer with us. So what we are dealing with is under Rule 149. 149, 3, where the minister, in case of a government bill, or a member, in case of a private member's bill, shall move a motion for reconsideration of the bill. So they are moving now a motion to reconsider. So they are bringing it back to the committee, and our dealings as the committee, are constrained to those clauses. That's why even I raised the matter that we are dealing with this bill, but how about clause 1 of the commencement date? How shall we handle that? Because it's not part of what the President is bringing back, which commencement date already passed. So are we going to set a law that operates back? I think I raised that in the House. So I think my colleague is quoting under the wrong law. What we are doing as a committee is the right procedure, because now this is a matter that has been brought by a new motion. It's not part of the work that elapsed with the 11th Parliament.
Honorable Kakoza 1 minute, and then Honorable Kefo.
I think to supplement what my brother said, if you read the framers of the Constitution, when the process of a bill ends, not until assented to, it's still a process that with business which has not been complete. If the President turned the bill within the days authorized by the Constitution, there is no way you can say that that business cannot be dealt with Parliament, because the process had not ended, and it ends with a time limit. So what we are doing, we are trying process a bill to end till it's assented to within a particular time of the rules which allows the president to return the bill. I don't see any offense.
Honorable Kefa Kiwanuka.
Yeah, I'm saying, I'm of the view that we're just complicating matters for ourselves. Because this is an ordinary process of returning the bill, and then Parliament makes its decision on it, and it's returned back to the President. So, and the issues that we are addressing actually are not major ones, very serious ones as such. So, in my view, we should just proceed and address ourselves to what the President is disagreeing with, and then make our decision on that.
Okay. Honorable, 1 minute.
Thank you, Chair. For records, my name is Chirumira Hassan, and I represent the people of Katikam South. Honorable Chair, rules are rules, and we have to respect them, else we are savages. The Honorable colleague raised a procedural matter, and as a member of the committee, I expected you to guide. But now when I hear honorable colleagues talking about what happened yesterday, then it even raises more questions, because the motion yesterday was very explicit on reinstating business that was incomplete from the previous parliament. Now this particular one he's raising is not part and parcel of what was debated yesterday. So that's why I'm seeking for your guidance, and then we get out of this. Thank you, Chair.
Thank you very much, Honorable. I think Honorable Kakos has raised a pertinent issue. If a bill has not been signed, is it complete? And if it is not complete, can it return to the House? Because a bill is only complete when the President assents to it. And if it is within the days, as Honorable Kakoza said, then it still remains pending business of the House. Let me ask Mr. Tamale Mirund to also add his voice, and then we can proceed.
Thank you, Chair. Honorable members, I think we need to be cautious when we are reading these rules of procedure. There are certain things which are not provided for in these rules. Honorable members, that rule that was cited by Honorable on pending matters deals with bills that are pending before Parliament. I'll give you an example. We might close Parliament and we have, let's say, a bill on marriage pending before legal, and you want to reintroduce it. You can move a motion under 249, 245 to reintroduce it. Those are the bills they refer to thereunder. Now, we have a bill that is passed by Parliament and goes to the President. The President is part of the legislative process under Article 91, because the President can assent to a bill or return it to Parliament. Now, the Constitution has dictated the procedures for such a bill. When Parliament passes that bill, Parliament becomes functus. In law, it cannot exercise any functions. It goes to the President. The President returns it. When the President returns it, we invoke Article 91, which tells you what to do, and the rule on return, 149, which tells you the processes when a bill returns. That's why these rules are separate. 245, talking about pending matters, and 149, talking about returned bills. Okay? Totally different things, because they apply to different areas. Honorable members, I wish to read for you what Article 91.3 says, 4th Chair. Says, where a bill has been returned to Parliament under Clause 3B of this article, that is the same article invoked by the President, Parliament shall consider it, and if passed again, it shall present it for the second time to the President. The constitutional mandate is a shall. That's why yesterday when the Speaker, you cannot even refuse that motion for recommitting that bill to the committee. Because the Constitution told you it is a shall. You must, as Parliament, reconsider. Because the President is part of the legislative process. So, honorable members, I request that we proceed, Honorable Chair, based on the fact that these are two separate rules, one on pending matters, and this bill is not pending before the House. Parliament had passed it, but the legislative process starts when a bill is initiated and introduced in Parliament and ends on assent. Before assent, but that bill has left Parliament. That bill can be returned to Parliament under Rule 149 and Article 91, not under the other rule, Honorable, you are quoting on pending business. I beg to submit, Chair. Thank you.
Okay, thank you very much for that legal clarification. I think the member is now convinced, so I think we can proceed.
Yes, Chair.
You can proceed.
I was left with only one item on excise duty amendment bill. The excise duty amendment bill was returned by the President, and he has only one concern about plastic bags. And the bill that was introduced by the House, by the Minister, had proposed amendments to Part 11 of Schedule 2 to the excise duty. And in there, the bill had proposed to change the tax payable on plastics. The current provision in the Act had prescribed a tax of 2.5% or United States dollars, $70 per ton. Now, that is what is in the Act. The bill changes that to propose a tax of 25% or US dollars 1,500 per ton. And the justification for this was environmental issues, to deal with environmental degradation posed by single-use polythene bags and polymers and sacks. So the President now says they have reconsidered this matter and they think that that is excessive, and is proposing that the provision should be amended to expand the plastics covered in there to include plastic granules, which the committee had actually amended, used in the manufacture of single-use plastic products, including disposable cups, and to provide those exemptions in this later. And also to reduce the tax from 25%, as had been passed by Parliament, to 2.5%, or United States dollars 70 per ton, whichever is higher. So, honourable members, those are the two proposals. I've set the processes for you. Your role restricted to only these two issues. Honourable Masaba, the issue of commencement, the commencement was not returned by the President. But a commencement of a bill can commence even 1st July, even if it is passed in August, even if it's passed in December that year. It can have retrospective application. It is allowed under the Acts of Parliament Act. So it is permissible.
That is why I raised that matter. Maybe you can elaborate it more. Sorry for grabbing the mic here, but that is something that is very important. These are tax bills collecting money. And under excise duty, we are collecting money on, like, tax on fuel. And you're saying it can act backwards. So maybe you can explain how it will act.
Okay. The retrospective application of the law.
Honourable members, under the Acts of Parliament Act, and I think section 8, it tells you how Acts of Parliament commence. It says an Act of Parliament can commence on a date specified by Parliament, like in this case, 1st of July. It can also commence on a date prescribed by the Minister by regulations. The Minister can issue a statutory instrument commencing an act and say, I direct that this act shall commence on 1st of July, whichever year. The third option is that an act can commence on its publication in the Gazette. So those are the three options how an act can commence. In tax laws, because the financial year starts in July, and these tax laws are intended to commence to finance the budget and to commence when the financial year starts, they always have the date of 1st July 2020, whichever year. But it does not mean, Parliament is not bad in whatsoever, under any law, to prescribe a particular date for commencement. So it is permissible that an act of parliament can commence, can have retrospective
Can I give
application.
information?
Yes, yes, Honorable.
I was in URA when Parliament scrapped motor vehicle license fees, and the president, for some reason, did not sign the law on time. We were forced to refund all the taxes that had been collected before the law was assented to. So is it in order that we can do things retrospectively? What are the consequences? Thank you.
Chair.
I think there is a, maybe you need to, yes, Honorable, you need to talk about that case, because I remember some people went to court. So there should be a judgment to that effect. What does it have, what implication does it have in this case if this law is going to apply retrospectively from 1st July?
Also, you have a hand, sir. Chair.
His income.
Yes, Right Honorable Chair, this matter of retrospective legislation in tax laws has been litigated over and over. What is required of Parliament is to ensure that the date of commencement is explicit and unambiguous. That is what Parliament needs to do. But maybe for the purposes of emphasis, we have a Supreme Court ruling in the Commissioner General of Uganda Revenue Authority versus Airtel. I think the legal counsel can provide a proper citation of that ruling, but is one of those laws that provides for an ambiguity and a clear intention of Parliament. And this particular case, we are saying that as long as the date of commencement is very clear, even when it is backwards, then that should suffice.
Yes, Honorable Amos Kang.
Thank you, Honorable Chair. Now, members, we shouldn't worry so much about these two clauses, particularly clause 1 that is talking about income tax on betting. Income tax is declared in the next month, before the 15th of August. That one you very know, for the previous month. And then this other one of excise is not being affected. That's why he's saying we leave the status quo as is. So we seem to be addressing ourselves on many issues, yet there is no particular implication in terms of tax. However, that's why the presiding officer and the authorities are saying we must expeditiously handle this, because taxpayers by end of July must declare their income tax. So that is the purpose. But for now, there is no worry.
Okay, kindly, Mr. Tamale Mirundi, continue, and then probably it can come up later. We can keep it in view and then discuss it exhaustively. You can also go and consult and then cite for us some of the legal provisions, and then we can, when we are maybe concluding and writing a report, then we can have good information. So kindly proceed.
Thank you, Chair. I think I had concluded. I presented up to the end. I was only addressing the issue, the procedure issue raised by Honorable Masava. But I'll look at it. But honorable members, there used to be a time when we're still applying, you used to have the budget passed in the new year, in the new financial year, when we used to have vote on account and all those things, until the PFMA came into force in 2015, where tax laws are passed with the budget before the commencement of the new year. So during that time, 2008, pre-2008, I think from 2015 below, government would introduce these bills to introduce taxes, and because they have been engineered in the budget, URA under the Tax Procedures Act had a provision that allowed them to collect these taxes even before Parliament had passed these laws. It used to be there. Unfortunately, because of time, I can't find it. I don't know whether it's still there. I have to look at the legislative history and see whether it was removed. But it used to be there. But now, with this new tax regime that we are, and I mean the financial system we are operating under the PFMA, it is assumed that these acts are passed, the bills are passed, tax laws are passed with the budget. So URA taxing cannot arise. But if we pass it tomorrow, Honorable Chair is saying that the obligation to declare these at the end of July will be applicable. So I don't think the issue of retrospective application in tax matters is a matter that we have been doing it since time immemorial, and the law allows us to do so. Thank you, Chair.
Okay, so thank you very much for that presentation. I think we have heard it all. So I can return the microphone to the chair to continue.
Thank you very much, and colleagues, thank you for participation. Council, thank you so much for guiding us through the processes. It's now time for us to reorganize ourselves and go to the respective clauses, the two clauses. We agree, and then we allow the technical team to do the report writing. Is that okay?
I think you're right. Given the guidance of the council, members, these two clauses are very clear. The argument in the income tax over land-based casinos, the president is saying there is some unfairness. You are taxing betting, online betting, with withholding tax of 15%, and you are exempting these ones who are ground-based casinos. So we must be seen to be fair. So that's why he's saying the definition is very clear. Winnings are defined. The difference between the stakes and the payouts. So the payout, now therefore URA should work out with the casinos to determine what is the winning for purposes of taxation. So for me, Honorable Chair and colleagues, I agree with the definition that is therein. So URA should, because initially URA was saying we are unable to monitor. So let them find a way, they will handle it in a it's management. And I know my colleague Honorable Begumisa knows that now it goes to URA for management purposes. Now on the other excise duty, the president is saying, hold on, we might be overtaxing them, because the word is saying the proposed increase is substantial, is big in nature, and therefore might affect our people. Why don't we wait and we do a research so that we see if this research can inform our policy otherwise? So in my opinion, the committee therefore would wait and say, we propose a research is done, because we are cognizant of what we are trying to defend, being the environmental concerns. So be it then as it is, let's address it through what we talked about initially, the research that is always needed for these policies to change. So in my opinion, I agree with the president on both, because the excise one is holding the status quo as research is done, and this one is creating a definition for fairness. Thank you.
Yeah.
Thank you, Chair.
Chair.
Chair, I'm also here.
May we listen to Dr. Kiwanuka? Over to you.
Thanks very much, Chair. I don't have strong views on the first one on income tax. But on the second one of excise duty, I'm sure those who were there in the 11th Parliament will agree with me that I made a fairly lengthy contribution within the limited time that I had. And I told the colleagues that this has been a controversial issue, something to do with the wars between, I think, those promoting paper bag and those promoting Caveira. And I said that we've lived with it for the last 10 years. And the president has tried very much to make sure that he doesn't suppress those who are involved in Kavera. After that, I don't know how we actually ended up with what was recommended. Honorable Kankunda, Chair Budget, can tell us. But we didn't finally agree on what is it that we are taking to Parliament. So, personally, I don't find much problem with that. He's just saying, let us keep the status quo. And actually, I don't know whether we need to, whether it's rewarding, but legal can do that, whether it's rewarding the way the president is proposing or just deleting that clause, that section altogether on the taxation that is being proposed. But that has been a problem which we've lived with in Parliament for the last 10 years. Personally, I dealt with it when I was in the Environment and Natural Resources Committee, and then also in the Finance Committee. Thanks very much.
Thank you, Doctor, for your submission. We appreciate your institutional memory on this. Okay, let's begin with the, then go, four of you.
Okay, thank you, Chair.
Could we use 1 minute only? Because it's coming
okay.
to half past 11.
I don't normally talk a lot. On the issue of income tax, I tend to agree with the reasoning by Honorable Kankunda to promote equity. There is no way we can tax one group and leave the land-based casinos, yet they are doing similar business. So I agree with the President's reasoning. And now on the issue of single-use plastics, I think the problem is bigger. What is the definition of single-use plastics? If we got a pipe, is a pipe a single-use item? Is it a multiple-use item? Because that creates trouble when somebody is importing raw materials for use in the manufacture of, say, these bottles or other items that come from plastics. So if we do not clearly define what a single-use plastic is, we will still have problems with the administration of this tax. So I don't know whether it's within our powers to request that maybe finance or URA properly defines. Either we get a list of what is included and what is excluded, or it is specifically put in the law so that it's clear as to what a single-use item is. Thank you.
Yeah, thank you. On income tax, you have no issues, but on excise, that's where you have a concern regarding definition of the single use. I believe that's what we shall unearth in the near future, particularly when the research product will be published.
Thank you, Chair. I also don't have an issue on income tax, an issue of fairness, and we need to bridge a gap, especially when it comes to taxation. But on exercise duty, that's where I have a problem. I don't know, my Chair Budget and the President, what they mean by research, because we have a lot of research from environmentalists when it comes to usage of plastics and how impactful it is on our environment. And the reasoning why these taxes are put in place, they are disincentive towards production of plastic materials, given the greater effect to our environment. And if you need such research, it's available. We do not want to waste a lot of time on doing research on things that are already available. Unless there is an argument that we need to give tax holidays, they must just come out openly and tell us we must give tax holidays to this group, like it happened on plastics. I think it was.
Granted.
Yeah, thank you, Chair, and thank you, Honorable Chirumira. I think the research is not about how the single-use Uveras affect the environment, and you're right about that. However, I hear the President where he says this is a substantial increase, and therefore that would mean that research should be around how much should be an increase or gradual increase that we should make given the environment in which we operate. Because we don't live in isolation, there are businesses that are already ongoing. How do you cater for all that, yet without negating the concerns of the environment? That's what I hear.
But Chair, like I've mentioned, the reasoning behind taxing plastic materials or products, it's a disincentive. Now, reduction from 25 downwards to 2 point what? You can clearly see there's unfairness given the existing research on the.
I think you need to read the letter again. You need to read the letter again. The proposal was 2.5%, but the recommendation that went to the President was 25%. That is almost 24 percentage points increase. But you wanted to know what research is? The academicians here will tell you. Okay.
Yes. One, maybe to, as you've stated, I have no problem with the President on income tax. I think his reason is proper. Why? The
go to next issue.
Yes.
You have no problem with that.
No, I want to explain it.
No, go to the next one.
The next one.
Yeah.
Also, I have no problem because of the reasoning of the classification.
Thank you very much. Over to you. Yeah.
Thank you, Chair. My name is Sarah Itungu, District Woman Representative, Kasese District. I want to agree with the President that the two issues he raises are really genuine, specifically on the first one. In regard to fairness and equity, really, we must not...
Okay. Do you have issues on excise tax? Yes or no?
On the second issue of excise tax, his proposal is very the research proposal is very good, because you cannot only propose a tax increase without looking at the consequences.
Okay, thank you very much for your submission. Back to Shadow Minister of Finance.
Thank you, Chair. I also don't have a problem with the first issue, but on excise duty, in my view, it looks like the increase on the tax on these polymer products was meant to be prohibitive, and we might appear to be, the government might appear to be contradicting itself at the time when NEMA is at the peak of its environmental protection activities.
Excuse me, do you agree that we need to conduct thorough research on this matter? Yes or no?
Research has been conducted, Chair, and
okay, you'll avail it to us so that we appreciate and then inform.
And Chair,
Honorable
Chair, I think people are misunderstanding that exercise duty. One of the reasons of excise duty as an item tax is for two reasons. One, as a punitive measure. Two, for tax correction. And the policy of research and information on data to put a tax must be conducted because you might affect the tax correction and also the punitive measure. In this sense, what the president is saying, please, the status quo should remain, not until what you are going to injure in tax correction and also punitive measure.
Well said, Honorable Kakoza.
Yeah?
All we need at this point in time is to embark on regulatory impact assessment. The findings from there will help open our eyes into what actually should be the next step forward. Thank you, Honorable Kakoza. Now, we are running out of time. We seem to agree fully to a large extent. That's unlike you.
Chair, as a former tax collector, I have a problem if they had budgeted for a certain amount of tax to come from this item. And then we say, let's reverse it, and it goes back to where it was. Now, where will that tax come from? So, would a middle ground work? Maybe we don't go up to 70. Can we go down to something slightly higher than the 25?
Can I volunteer information, Chair? Yeah. The tax measures, once they put a policy on an item, the status quo was 2 point something. And within the original bill, that's how it was. That means the calculation of tax measure was already an input within the bill. But committee in its wisdom is the one which amended to increase the what? The amount. So which means the achievement of government which had proposed 2.0 as a status quo, that amount to be corrected. If you reinstate it, the government will not lose any amount.
I agree, Mr. Chair.
Okay, thank you. Now let's move to the next step, and I would request. Okay.
Thank you, Chair. I just wanted, I agree entirely with the colleagues and the President, but I wanted to say just one thing. In future, as we are handling these bills, it appears, especially to the new members, as if we are saying, now we agree with the President on the equity and what, and yet this is the issue that we discussed as the committee. And we were misled by finance and other technical officials who said, no, you know, there is no way we are going to collect this money from the how are they called? They collect the money on source. So they were proposing that it is easier to collect online. So the issue I'm trying to bring, that members should not think that we did not look at this, and the issue of equity was not addressed at the time when we are considering this bill.
Point of order, Chair. No, order to you.
Order to who now?
To Honorable Umali.
No, it's not on the. Okay, Honorable Masaba, you have something? You remember we said at the beginning yesterday that we are a team and we should move as one. So the principle of unity to me matters a lot. So, Honorable Masaba, bear that in mind.
Thank you very much, Chair. And I'm one who believes in unity and who believes in consensus, but I do disagree with the President's letter. And on that matter, I do disagree with sorry, I thought you were all getting me well. I do disagree with the President's letter, and I think once we fail to agree I'll have a minority on that, because this is a matter, yes, this is a matter we've had wide discussions, and I think I'm one of the few members who has the most information about this matter. And there has been a lot of lobbying for the last 5 years on this matter. So,
Could
no,
you kindly,
I'm on the excise duty. On the issue of casinos, I do agree with the president, and I think that is quite clear. But on the issue of excise duty, I do disagree with the president. And when you look, actually, in my view, the president is misguided by the technical team from the Ministry of Finance. Why? It's Finance, Ministry of Finance, that brought these proposals, the 25% and the 1,500 per ton. It's not the committee, because I heard Honorable Hakoza stating that it's the committee adjusted. I have the original bill here, which was brought, and Chair, you can have a look at it. It's Finance that brought it before the committee.
What rate is there?
The rate, they increased 25%. Was the original bill? You opened the original bill, the second schedule, the excise duty. So it's Finance that proposed to increase this. And as a committee, we went with the decision of Finance. I actually, in my minority, I think I've had a minority on this, and the floor has agreed with me on several occasions. On the last 2 times, I think, the House adopted my position. Why? You're looking at it innocently, but Finance brought this matter and proposed this increment. So the committee decided to go with what Finance brought and passed it. But there were amendments that we proposed and brought back. So I want you to compare the original bill, compare the law we have, and compare the president's letter. They're different. So you're looking at the rates, but it's not about the rates. It's about creating an exemption for people producing other plastics. So when you look at the president's letter and the position the president wants, it's different from the original law, and it's different from what Finance. I don't know if we're on the same page.
May I request the council, did you listen to him?
Are you getting my point?
Did you hear what he said?
When you look at...
Did you understand what he said? Could you respond?
Okay, let me conclude for him. When you look at the original bill, the law, tax laws, under Section 11, that is where all plastics are charged a tax. And all plastics are paying taxes. When you look at the president's proposal in his letter, there are more plastics that are going to be exempted. And when you look at what we had passed here, we had captured, and other plastics. I don't know if I'm clear. So what the position the president's giving us is the position the Minister of Finance had brought the other year, and we chased it as a committee, and I had this argument on. I remember if the councils can intervene, we had the technical team from the URA who agreed, who conceded, and that matter was settled, but it has been brought back. So he can advise, but I think if we do not agree on that, the rates, there is nothing wrong with the rates, but the definition is changing. I don't know if you've been critical enough to look at the definition. So the president, they are using the argument of the rates, but they are changing, there are things they are changing the definition. Thank you, Chair.
Honorable Kakoza.
My brother, who? I'm sorry, from Bari.
Honorable Masaba.
Honorable Masaba. You see, with taxation laws of tariff rates and classification of items, depends with the intention of bringing that excise on it. The reason is simple. Once an item is classified in a certain HS code, the tax implementer will go directly and apply that rate. Not all plastics are classified under the same method. There are some which are biogradable, there are some which are not biogradable, and there are some which are of reuse. That exercise there, it has 2 roles to play. You have to eliminate factories who are using plastics, which are the polymers, which are really spoiling the environment. How do you do it when the factories were already here? One, you say, please, we start gradually till we eliminate you. You don't come and say, go out, because you are going to injure the economy. So the best way to do is, I'm not sure of the tariff rate which was in the principal law. The president is saying, let's first stay on that, so that we know we should not injure factories which are employing many people, and you rush to punish them and get out. Say, do it gradually. In the next financial year, and I want to inform this committee, rarely the problem we have in this country, people who are bringing tax measures, they don't first make a research. They don't revisit the policies to know how they have injured the economy. So the president is saying you can rush to go to amend 25%, but you've not made a research. Maybe even that's why the president is questioning. He's saying, how do you go to this without a data, without information or need how we have injured? For me, we can be patient. A year is not too much. If we remain with the status quo, we task the Minister of Finance to give us data why it came out with 25% from 2.5%, because the reason, you see, it's abnormal to put canons of taxation beyond what can be affordable and what is equity. Somebody with a factory, you are telling him now, I'm punishing you, get out with your equipment and what? Give him time. And that's why that exercise was put there for a reason. Please, you people, you're affecting the environment, the factories we are here, but please, can you now try to find other methods that when you're manufacturing products used by biodegradable, because they're exempted there, don't use polymers that plastics which are not biodegradable. And the HS code of those items are classified. So a tax collector will go directly and say, the raw materials you brought are plastics and polymers cannot be used in this country allowed. So you face that charge or punishment. And I think Mr. Protazia can bail me out that all items imported must be classified, and also that's why the president is specific on polymers. The classification of polymers is not the same as plastics. They are totally different. So I do agree with the president that let's not rush to increase because we want tax to get money. You might be affecting other people without a research. And basing on that, I think as a committee, I beg that let's task the Minister of Finance this time to bring a researched data that any tariff rate increase must be based on facts rather than putting them there. Finance has got that problem. And the committee must be thorough now that please, any tariff rate increase, give us a research. I beg to submit.
Thank you very much, Honorable Kakoza. You have really said it very, very well. One management consultant one time said that if you cannot measure something, surely, if you can't manage it. Let us be patient, as the President said, and carry out the research so that we know the impact of whatever rate that is being proposed has on the economy. Based on that, that's when we can now take on at whatever rate to withdraw whatever amount of money from the economy and also manage other sectors within the economy. Over to you, my brother.
I'm called Gilbert Agaba. I have an issue on excise duty. Honorable Kakoza, you seem to be rushing on HSC classification, the harmonized system. That comes on the implementation stage when URA is doing the actual collection of taxes. Here we are not yet on the classification of polymers, plastics, and other items in the manufacture of plastic items. That's on classification when an agent is capturing an entry to present to customs. That's an end process. We need to first know, some of us were not in the 11th Parliament. We do not know how this bill started. We did not even know that this was a proposal from the Minister of Finance. If they proposed, why are they rescinding on their proposal? That's number one. Number two, have we been availed with all the documents to see how the bill started, to see who proposed what, and who put which input, so that we make a decision. You cannot call me early morning, you give me a document in the morning, and you want me to make a decision in less than 1 hour about a sensitive item like excise duty, which is going to affect the whole economy. So I'm not rejecting the president's proposal, but I'm requesting, give us at least 1 day. We read how this bill started, who proposed what, we see what are the president's proposal, then we come up with a decision. But let's not hurry to come up with a decision on a sensitive matter. The issue of withholding tax, I have no issue because it is even claimable.
Yeah,
if
thank
you are a
you.
good taxpayer,
You
you
have
can
made,
claim.
you have made your point on the income tax.
Income tax is good.
You have made your point, and we thank you for that.
But excise duty, give us at least 1 day, we read. I asked the clerk at night to send
How
me a
many?
letter.
How many want?
I did not.
How many of us want 1 day to read? Okay, we shall issue the documents, and then.
Because issues are coming in which we don't know. Honorable Masav is raising an issue that this proposal was made by Minister of Finance. We did not know.
Okay,
we are
maybe
here going
could somebody walk us through the legislation process quickly so that he appreciates?
I'm not coming in on the legislation process, Honorable Chair, but rather I wanted to put the record straight, particularly what the Honorable Gilbert is referring to regarding what Honorable Kakoza submitted about the harmonized system code, or rather the classification of all those items which are raw materials. The granules and modules, polymers, are materials which are imported by manufacturers to produce those Vuveras. So it's not an end product as such, because it is a raw material. It has a direct bearing and affects our manufacturing concerns. And that's what the President is saying. So Honorable Kakoza is right that you have to address it and see whether it is going to affect our manufacturers or not. And in my opinion, I think it does affect, if you shift the rates right now, it does affect the manufacturers. However, the issue of who introduced what, honorable colleagues, whether you go back and read, the facts have been stated. The rate earlier was 2.5, the proposal is 25. So even if you go and read who proposed what, who brought it, it will end. Do we agree with it? Do we need more research? And that is the point. Yes.
So in short,
Chair, can I try to fill members on what we've had around this?
Okay, thank you.
Okay, basically it's something that has been going on for a long time. This one on plastics. In the 10th Parliament, we had a big war, which on one side was being led by NEMA, Ministry of Water, actually even other agencies like NBS, who wanted actually Kavera banned. And then on the other hand, we had the Ministry of Trade and Industry and others who are involved in Kavera, for them saying, no, it should not be banned, it can be recycled. And actually the war was being fought at a very high level, ministers involved. And at that time, we were trying to come up with a law on NEMA, the National Management Environment Act. It was very difficult. Finally, I got Honorable Lugunda, who was Prime Minister then, who came in to bring the two sides together. And we agreed that, okay, let us have a procedure, let us have in law that all industries, all factories who are involved in something to do with the Buvera will be doing recycling. Then when we agreed on that, we managed to pass that law. Then the industry on recycling started booming. That's the industry of Buvera. Later, again, some people came back with something forged. Again, very interesting, it was brought by one of the ministers. But forged, saying that actually the president has directed that they should be banned on Buvera. We had a meeting on that and resolved it. Then later, the Ministry of Finance failed to, no, URA failed to tax where it was supposed to collect tax, the Buvera. And the Ministry of Finance decided to exempt virtually all of them from paying tax. Then they came up with another law in the 11th Parliament. That law that they came up with was suggesting a certain tax with some other groups exempted. But then the president again refused to sign that law. I think that, I guess members are clear about that. Then when the president failed to sign that law, the whole thing ended up very confusing. And then later we had this one which was introduced, the 2.5 and 2.5% or $70. And that is what has been operating. But the main problem has been that if you introduce the tax on Buvera, as people had intended actually to use it to ban Buvera on the market, that you somehow affect the industry which the law helped in setting up, the industry of recycling. And that will go a long way in affecting those factories where actually some of them may even sue government or may complain about the uncertainty of government taxation policy where industries are allowed to set up, and then you come up with a tax later which affects them, and then they have to go out of the market. So the whole thing has been moving along those lines, making it very difficult. If you introduce the tax on this, what's going to happen on the factories that have been allowed to set up to do the recycling? And actually, there is a very big thing about that, which I think we visited very briefly which we saw in some of the reports in the 11th Parliament. But I don't know how eventually all that was considered.
Honorable, you have made your point, and I think we need to appreciate the potential impact of those rates on the respective sectors of the economy. And to do that, we actually need to carry out the research as the president.
No, Honorable Chair, let's not put politics.
I have not yet given you.
You may not give me yet, because I don't want to be part of the minority report. You must allow us to also air out our views so that we don't air them in the minority reports. You cannot rush into scrapping an increment which you passed in your own sound minds. Number one, if we do not want Kavera in Uganda, I'm sure this kind of increment was put on to punish or to discourage manufacturers of Kavera from manufacturing Kavera. URA does not only collect taxes, it has other roles to play. Even protecting an environment, NEMA can use URA to protect the environment by disabling factories in manufacture of Kavera from coming on board. Now, this is a matter which has been in Uganda. I've not been a member of parliament, but I've been a Ugandan. This matter has been on for more than 10 to 15 years. Talking of how can we protect our environment by discouraging manufacturers of Kavera. Now, here we are saying let's put excise duty on importation of polymers or raw materials, in importation of raw materials to manufacture Kavera. Now you are telling us that now allow them to import at a low rate so that you can encourage people now to get employment in the Kavera factories and people to set up Kavera factories. I think this is wrong. If we had put this tax to punish or to discourage manufacturers of Kavera from manufacturing or from importing or from doing whatever they do to put Kavero on the market, we may not maintain the rates, but don't again maintain the status quo. At least increase something, as Dr. Protazio had suggested, increase something so that we can discourage these people. Increase something.
No, I think that's where research now becomes important.
Yes, but now research cannot be done after agreeing with the status quo. You cannot say we have agreed with the status quo but go for research. When shall we review?
Listen, the incubation period of research work is not 1 hour, not 1 day.
I said you have to give us some little time to understand these things. Because you cannot do research in 1 day and also maintain the status quo in 1 day or increase in 1 day.
Can we listen to the wise counsel here?
Honorable Chair, this proposal we now understand was made by the executive, the Minister of Finance, who in principle is the president. So they came here and proposed 25%. Now this committee agreed and passed this, and ultimately Parliament passed it. Now they have come again and said, wait, we need to correct this and maintain it to where it was before because of the emerging information probably or other issues that have happened in between. And now they are saying, let's first conduct research and be able to come up with another position in the future. Why should this committee stampede that proposal? Maybe what Honorable Protas, the Commissioner raised, I think for me would be the most pertinent one, which said, if 20%, if 25% increment was part of the financial modeling for our revenue projections for the financial 2026-2027, what will happen to our resource envelope if now we are getting back to 2.5%? And this is a case where the Minister of Finance needs now to tell us where now this money is going to come from.
Now, I think we should not worry much because that will have to be factored in the model again so that we find what we call the balancing item. Basically, the net credit to government. The net credit to government will actually help us identify the potential source of that gap. So we should not really worry so much. After all, we are not the fiscal authority. The fiscal authority is the Minister of Finance. URA merely does the resource mobilization or the administration of tax laws. So I don't think we have the technical capacity really other than Minister of Finance. And this is their baby. Thank you.
If you may allow, Chair, my honorable colleague, my immediate neighbor, has made a valid point. So in our report, we would only request finance to speak to that. That is all. But make sure that we observe it in our report.
Noted. Honorable Kakoza.
One, for the purpose of the record, I don't think colleagues, some of us who have been practicing this for quite a long time, even Kankunda knows we've been practicing taxations for quite a long time. There is no way when they put exercise tariff on any product and it doesn't leave a privilege to others. Like when you import and manufacturer, they cannot put you on the same level. And two, any item, according to World Trade Organization, it must be classified. So if you're importing a raw material, you cannot be at the same tariff rate with that one who doesn't import a raw material. So, Chair, I want to convince this committee that 1 year is not long. Because why the policy of tax measures are revisited each every year is to check on the policies we passed, how do we manage them, and how deal with them.
Honorable Masaba.
Chair, I need you to or the legal counsel to guide us. Because if we want to achieve what the president is stating, maintaining the status quo, then why do we have to recommend as a committee to go with the president's position? Why don't we just delete? Because when we delete, it means we are maintaining status quo. But when we adopt the president's position, it's changing. It's not maintaining status quo. As we move forward.
Thank you, Chair. Honorable Masava, if you look at the current law, that law had HS codes for plastics that were liable to excise duties. If you look at the president's proposal, those HS codes are not there. That is the first difference. The second difference is that the current law did not list the plastics that were liable to excise duty. The president's letter lists them, and I can read them. The president says, plastic granules used in the manufacture of single-use plastics. That is the first category. The second category is single-use plastics, plastic products, including disposable plastic cups, lids, plates, cutlery, bags, sachets, bottles, straws, sterilizers, cling films and wraps, jars and lids and sacks and bags of polymers of ethereal, except, and the exemptions proposed by the president are already in the law, save for, I think number 4, plastic granules used in the manufacture, blah, blah, blah. So the president's proposal only maintains the 2.5% tax or 70 USD per ton, which is in the law, but the others, in accordance to, as I told you, the principle of legality, you clarify what you want to prohibit. He has indicated clearly the plastics that are liable for excise duty. So that's why we cannot just delete. We are but it is up to you to adopt. If you agree with the president, you adopt the proposal by the president. It is not a deletion of what is here or a deletion of what is in the Principal Act. You adopt the proposal by the president. And if you do so, then you delete, you replace what is in the Principal Act. Honorable, thank you.
Why, Chair, why I've raised that, Council, plastics, for example, nice, Luca, whatever plastics they're producing, plastic cups, whatever, jerry cans,
Honorable Kakoza,
where are they taxed according to the president's proposal? When we adopt the president's proposal, where will they be taxed? Where will they fall?
If they fall under the single-use plastics that are enumerated in the president's letter, and they fall under either they are plastic cups.
No, I'm talking about they are not, everyone knows they are not single-use plastics. For example, these plastic cups, basins, those are not single-use. So the difference, what I'm looking at currently, all those plastics are being taxed. And when we had that discussion, in order to capture that, we agreed to a common ground. When you read the law, it includes and all other plastics. So it includes plastics that are not captured in those codes. I don't know if you're on the same page. But when we go with the president's proposal, we are now giving an exemption to these factories that are producing plastics that are not for single use, but have been paying taxes under the old rate. I don't know if we are on the same page.
Honorable, I understand you, Chair, through you. I understand, Honorable Member, but my challenge is that for me the President's letter is very clear on what the President wants. And if that is what he wants, as the head of the Executive and Cabinet, which is in charge of policy, that is not a legal issue, okay. Honorable.
Chair, that is what I wanted to make clear because it will appear in my minority. We are, the President, the President has been
determined to go.
Because they are rates, I agree with the President on rates, which is okay. The rates are high. We need to maintain the old rates. But where I disagree with the President is where we are now providing exemptions to certain plastics, to most of the plastic producers, under the disguise of rates, because the President's argument is about the rates being high.
Okay, what's your proposal?
My proposal is that we change the definition of the President and capture all plastics and include all other plastics, as we had initially done,
And what would be the impact of that on revenue collection as well as the environment?
When you look at the president's proposal, actually we will be collecting.
I mean on your part.
When we look at the president's proposal, we are going to be collecting less taxes, actually. Even
how much?
with
I
lower
mean, how
rates.
much is that?
I do not, I need to look through the documents.
That's why we need
but
research.
I'm going to get you. No, Chair, what I'm stating, when we go back the old rate, that is being used now as the present proposal, we will be collecting certain monies. But then, when we exempt the biggest part of those producing plastics, we are going to lose revenue. That's automatic. I do not need to do research on that.
Thank you so much. When you read the letter from the president, particularly where he says plastics, he starts by saying, I wish you flash it on the screen for colleagues to see. He says plastic granules used in manufacture of single-use plastic products. And that is very critical. Single-use plastic products, and mentions the particular ones, including things like cutlery, you know, our forks and spoons, which are single-use. But as you conclude, he says, except, this is an exception to the rule that he has mentioned up. Because these, the ones which are single-use, are the ones which are attracting 2.5% or $70 per ton. He says except, and I think what the Honorable colleague Masawa is talking about, when you look at the 1, 2, 3 Roman numerals that the President is saying should be exempted, under 3 he says multiple-use plastics and plastic granules used in manufacturing of multiple-use plastics, like jerry cans, cups that you use again and wash and use, those are multiple. So that's where they fall. That's where they would fall.
Chair.
Okay.
Let me.
Yeah? I want us to converge to one point.
Yes, Chair, me, I'm in agreement with the rates. But the definition, I think, will have, I'm going to have my view, and then let the technical. But the issue of the rates, I have no problem with whatever the president, because it's what we had made initially.
I don't want you to go away alone. I want you to be with us together as one unit. Before you come in, can I listen to Honorable Kakoza? Honorable Kakoza.
One, what Honorable Masawa should not get worried of. Once you agree with the tariff rate, the classification of such an item imported is within the HS code. Because every item, like I can take an example, cotton plus nylon, when you're importing them, you don't pay the same rate like somebody importing cotton, because the HS code is defined. So if you're agreeing with the rate, the definition, the tax collector will put that item physically where it belongs to sit in the what? The rate. So there is nobody who has a classification of an item apart from the harmonized system code. So it's defined, and it's a matter of classification. Once you agree with the rate, the tax collector knows what you've imported, and will put it in the same category of those items you've imported.
All right, I think now let's go close by close. Then we get ourselves ready for report writing. Now, Clerk.
Chair.
Yes, please.
Thank you, Chair.
Minister of Finance.
Yes, Chair, I want to put you on notice that I'll also come up with a minority report.
I think it's too early for that. Let's first listen to our inputs close by close. Then, as we wind up, you can declare that. Okay?
Most obliged.
Thank you. Clerk.
Thank you, Chair. I'm going to read the proposed amendments by the President to the Income Tax Amendment Bill. Brain, please project. Project. So it's on page 2 of the President's letter. Yes, page 2 of the President's letter, and 1 reads as follows. Clause 11 of the Income Tax Amendment Bill 2026 be amended to read: the Principal Act is amended by substituting for Section 131 as follows. 131. Withholding of tax on payments for winnings of betting or gaming. 1. A person who makes payment for winnings of betting or gaming shall withhold tax on the winnings at the rate prescribed in Part 11 of Schedule 4 to this Act. There is another meeting.
Can we proceed, please? Okay, clerk, take us through the bill.
The bill.
One meeting, please.
So, honorable members, the President is proposing one amendment to the Income Tax Act in Clause 11 at page 2 of this letter to substitute the proposed Section 131 as follows. 131. Withholding of tax on payments for winnings of betting or gaming. 1. A person who makes payment for winnings of betting or gaming shall withhold tax on winnings at a rate prescribed in Part 11 of Schedule 4 to this Act. 2. For purposes of subsection 1, winnings means the difference between the payout and the staked amount. 3. This section does not apply to winnings paid by a person licensed to conduct a national lottery under Section 23 of the Lotteries and Gaming Act, and that is where the President wants us to stop. The effect of this amendment is that we should have deleted the proposal in the presentation copy to exempt land-based lotteries from the application of this Act. Thank you, Chair.
We are all in agreement with that. Thank you very much. I pray we also agree on the next one. There is a...
Thank you, Chair. The next one, the President is proposing an additional amendment to the Excise Duty Amendment Bill 2026 as follows. The President proposes in Clause 2E to substitute paragraph 11 with the following. 11. Plastics. A. Plastic granules used in the manufacture of single-use plastic products. Single-use plastic products including disposable plastic cups, lids, plates, cutlery, bags, sachets, bottles, straws, and stylites, cling films and wraps, jars and lids, and sacks and bags of polymer of ethylene, except 1. Vacuum packaging bags for food, juices, tea, and coffee. 2. Sacks and bags for direct use in the manufacture of sanitary pads. 3. Multiple-use plastics and plastic granules used in the manufacture of multiple-use plastics. And 4. Plastic granules used in the manufacture of plastic products used for packaging pharmaceutical products and plastic products used for packaging pharmaceutical products. And that is the end, and proposing a 2.5% tax or US $770 per ton, whichever is higher.
Thank you, Council. Are we in full agreement with this as well? What do I hear?
Honorable Chair, meanwhile, I'm not yet in agreement with the exercise duty.
Okay.
Some taxes are preventive in nature, not only
we
for
have
collection purposes.
We have already debated this. I think, could we request Minister of Finance to be here with us so that we harmonize the two positions? Is that acceptable to us? Chair, Budget.
Honorable Chair, I would prefer you refer to me as a member of the committee. Honorable Chair, I would like to agree with what you've said, because it does no harm to hear from them, since it is said they're the ones who had initially brought the opinion. However, I would propose that we go ahead with the draft report, the majority position, so that tomorrow when we meet with them in the morning, we conclude and the report is ready for signing.
Acceptable? Honorable Kakoza.
I have no problem.
Honorable Chan. Honorable Minister of Finance, Shadow. Shadow. Are you in agreement?
Chair, I have no problem with inviting the minister. But
tomorrow. No more debate. Tomorrow.
It's okay. I'll present my case tomorrow.
Thank you
on
very
those
much.
issues I'm not comfortable with.
Protazia.
I'm in agreement.
Honorable Masaba.
I'm in agreement.
Thank you. Honorable.
I'm in agreement, Chair.
Council.
I'm in agreement.
Over to you.
Yeah, I'm in agreement with that.
Chair, I'm in agreement.
Arua.
I agree to that.
Okay. Are you in agreement? Yes or no?
Minister can join us.
Thank you very much.
Okay.
I think we seem to have come to the end of our deliberations on the two, and as proposed by a dear colleague, that our clerk can now begin drafting the reports as we await to meet the minister tomorrow. Next item.
Adjournment.
I want to thank you people so much for participating in this meeting. The meeting is adjourned to tomorrow 10 o'clock. Sempeni.